All right, ever get that feeling like some arguments just go in circles? Well, the legal world has a way of hitting the brakes on that. It's called claim preclusion.
Exactly. Claim preclusion is all about efficiency in the legal system, making sure we don't have courts bogged down with repeat cases.
So if I sue someone over a fender bender, I can't come back later and try to sue them again for the whiplash I didn't realize I had at the time.
You've got the right idea. It's about ensuring judgments are consistent and, frankly, saving everyone involved a whole lot of time and energy.
Okay, so how does claim preclusion actually work? What are the legal hoops you need to jump through for a judge to say, nope, we already covered this?
Imagine a three-legged stool. You need all three legs for it to stand. In legal terms, those three legs are identical parties, identical causes of action, and a previous judgment on the merits.
All right, identical parties, same people, same problem. That seems pretty straightforward. But I bet there's more to it than meets the eye.
You're absolutely right. Take, for instance, Nevada v. United States, a fascinating case from 1983 that went all the way to the Supreme Court. It all started with something that can get pretty heated: water rights in the Wild West.
Water rights in the Wild West. Okay, this is already sounding more exciting than my law school textbooks. Tell me more.
So picture this. Way back in 1913, the U.S. government filed a lawsuit to secure water rights for a Native American tribe. They reached a settlement in 1944. Fast forward to 1973, and the government is back in court. The tribe needs more water for things like environmental preservation. They name all the same people from the first lawsuit, but this time they add some new parties who started using the water after that initial agreement.
Okay, I see where you're going with this. So the question is, were these new parties considered identical, even though they weren't around for that first lawsuit?
And the Supreme Court's answer was a resounding yes. They brought in this concept of successors in interest. Essentially, those new parties were stepping into the shoes of the original ones because they were now the ones using those same water rights.
Wait, so you're telling me that even if I wasn't directly involved in an original case, if I somehow benefit from the same issue later on, I could be bound by that earlier decision? That's wild.
It is fascinating how interconnected things can become, isn't it? It highlights how claim preclusion isn't just about the specific individuals in the courtroom, but about anyone who might be standing in their place further down the line.
That's a lot to think about. Okay, so we've tackled identical parties, and sometimes it's more than meets the eye. But what about that second leg of the stool you mentioned, identical causes of action? That one sounds tricky.
It can be, because it's not just about using the same legal terms. It's about whether the heart of the issue stems from the same set of facts.
I bet you have a good example up your sleeve.
Always. Let's rewind to 1952 with the case of Kydetz v. Albany. Picture this: a house with a bit of a sinking problem.
Literally sinking. This sounds like the plot of a movie.
Right, so Kydetz buys this house from Albany, the seller. Turns out the house is built on land that, well, has a tendency to sink. Not exactly what you'd want in a dream home, right?
Not at all. So what happened?
Well, in the first lawsuit, Kydetz claims Albany tricked him, and he wants to hit the undo button on the whole house sale, legally speaking. That's called rescission. Albany fights back, arguing that too much time has passed, bringing in the concept of the statute of limitations.
So round one goes to the seller because of a time limit, not because the house wasn't sinking.
You got it. But here's where it gets interesting. The judge, maybe feeling a bit sympathetic, tells Kydetz he could try suing for damages instead of trying to undo the sale altogether. But instead of taking that route, Kydetz decides to start a whole new lawsuit.
Same parties, different legal strategy, but still about that sinking house. What did the court have to say about that?
The court essentially said, you only get one shot at this. Even though Kydetz switched up his legal approach, it was still fundamentally about the same problem, that sinking house. They decided this second lawsuit was barred by claim preclusion.
Okay, so that makes sense, but I can see how this could get murky. How do courts determine if it's truly the same set of facts when the legal arguments change?
That's where the transactional approach comes in. Courts now take a broader view, looking at the big picture. What's the main event that sparked this whole legal battle? If it's essentially the same, even if the legal specifics are tweaked, claim preclusion might apply.
So one car accident, one transaction, even if you try to sue for different types of damages.
Exactly. Clancy v. McBride, a case from 1929, really highlights this. We're back to car accidents, but this time, our plaintiff tries to get a little clever.
Oh, I'm sensing some legal shenanigans. Lay it on me.
So Clancy gets into this fender bender with McBride. First lawsuits, Clancy goes after McBride for the damage to his car and wins a cool $275. But here's where it gets interesting. Clancy decides to try his luck again, filing a second lawsuit for personal injuries from that same accident.
Hold on, he split the car accident into two separate lawsuits, trying to get paid twice for the same fender bender? Was that even allowed?
Back then, the court actually let him proceed. They figured, hey, different rights were violated, so it's a different claim. But here's where it gets interesting for us today. Nowadays, courts are much stricter, using that transactional approach we talked about. Clancy would have likely been blocked by claim preclusion.
So one accident, one lawsuit, even if it involves different types of harm, it definitely keeps things tidy. Speaking of keeping things in order, let's talk about that third leg of the stool. A final judgment on the merits. What exactly does that mean?
You're right. It's not enough to have just any decision in the first lawsuit. It has to be a decision that truly dug into the heart of the matter. It means the court issued a ruling based on the actual substance of the case, not just a technicality.
Okay, I'm following you. So what counts as a technicality in this context?
Imagine a case gets dismissed because the plaintiff filed their paperwork late or sued in the wrong court. Those are procedural issues, not decisions about the claim itself. Those wouldn't usually trigger claim preclusion.
So if a judge dismisses a case for those reasons, you might be able to bring it again with all the right paperwork, of course. But if the case goes to trial and a judge or jury decides one way or the other, based on the evidence that's a judgment on the merits, and claim preclusion would likely come into play.
Exactly. It ensures that the court has fully considered the heart of the issue before applying claim preclusion.
This is all making a lot more sense now. It seems like claim preclusion is a pretty solid rule, but are there ever exceptions? Times when you can go back to court over something that seems similar to a previous case?
Great question. And the answer is yes. The law is rarely black and white. There are always exceptions.
Okay, so what are some scenarios where claim preclusion might not be an ironclad rule?
Let's say, for instance, both parties agree to split their claims to simplify things. Or maybe there are jurisdictional barriers, meaning the first court didn't have the power to hear all aspects of the dispute.
So sometimes it's more practical or even necessary to split things up. What about those recurring wrongs you mentioned earlier? Like, what if someone keeps parking their giant monster truck on my prize-winning petunias? One lawsuit per parking infraction.
That's a perfect example. If it's an ongoing issue, like harassment or, yes, repeat offenses involving your precious petunias, you wouldn't be barred from seeking legal recourse just because you've dealt with the same problem before.
Thank goodness for that. What about situations like divorce or child custody cases? Those often involve ongoing changes and adjustments.
You're right. Those are also classic examples where exceptions to claim preclusion might apply. These are complex, evolving situations, and courts need flexibility to ensure fair outcomes over time.
This has been incredibly helpful. Before we wrap up, any final words of wisdom for our listeners as they navigate the legal landscape, now armed with their newfound knowledge of claim preclusion?
Remember, the legal system, while complex, aims to be fair and efficient. Claim preclusion plays a big part in that. It helps prevent repetitive litigation, which saves everyone time and resources. But, like we discussed, there are nuances and exceptions woven throughout.
So if you think claim preclusion might be relevant to your situation, what's the best course of action?
Don't hesitate to reach out to a legal professional. They can analyze the specifics of your case, taking into account all the twists and turns and give you tailored advice.
This deep dive into claim preclusion has been, well, eye-opening. I feel like I've leveled up my legal knowledge today.
It's one of those legal concepts that might seem a little obscure at first glance, but it really does impact so many aspects of the legal system.
Absolutely, and it's working behind the scenes to keep things running smoothly, make sure cases move through the system fairly and without unnecessary delays.
Exactly. And it really highlights how important it is to have a sound legal strategy right from the get-go.
Right. As we learned with those car accident cases, trying to split up your claims, well, that could seriously backfire.
Precisely. It's crucial to really think about all the potential angles of your case early on to avoid running into trouble with claim preclusion later down the line.
This has definitely given me a lot to think about. Any final thought-provoking questions for our listeners before we wrap things up? Something to really make them go,
This whole discussion about claim preclusion and identical parties got me thinking about class action lawsuits.
Oh, interesting. You mean where a large group of people is impacted by the same issue?
Exactly.
Yeah.
It makes you wonder how claim preclusion works in those situations. If you've got a whole group of people who are affected, but some of them weren't technically part of that initial lawsuit, what happens then? Could they bring their own claims later on, or would they be bound by those successor and interest rules that we talked about?
Now, that is a question for our listeners to ponder. It adds a whole other layer of complexity to what's already a fascinating area of law. And on that note, we'll leave you with that thought-provoking question. Thanks for joining us for another deep dive.
All right, so today we're going to dive into some pretty interesting legal concepts. And these are terms you might have heard before, but maybe not totally sure what they mean. We're talking about claim preclusion and issue preclusion.
And we'll break those down so they're crystal clear and importantly, talk about why they should matter to you, because this isn't just legal jargon. This is about how the legal system tries to make sure the same arguments don't just keep bouncing around the courts forever, you know?
Right. It's about fairness and efficiency for everyone involved.
Yeah.
So let's start with claim preclusion. Imagine, let's say, you're suing someone over a broken contract, a promise that wasn't kept. Claim preclusion essentially says, look, you get one shot to bring all your complaints about that specific contract to court.
Yeah, think of it like you got to lay all your cards on the table at once. You can't keep coming back with new bits and pieces of arguments about the same contract later. What you could have brought up the first time, that's it.
It's about preventing, like, these piecemeal lawsuits and making sure everyone's using the court's time efficiently.
It's exactly. Streamlining things, resolution for everyone involved.
Okay, so that's claim preclusion, one claim, one chance. Now, how does issue preclusion fit into all of this?
So issue preclusion it's a bit more specific. It's not about the entire claim, but specific arguments within a case. So let's say in our contract case, you argue that a certain email, right, a piece of evidence, that email proves the other side agreed to a certain term in the contract. If the court makes a ruling, a firm decision on that email and what it means, boom, neither side can re-argue that same point in another lawsuit, even if it's a totally different contract dispute this time.
So it's like, we already had this debate and we have a decision, let's move on.
Exactly. And it prevents, contributing to this idea of we want consistent rulings, fairness for the party who won that argument the first time around, right?
Yeah, that makes sense. So to really see this in action, I think it helps to look at a real case. And we've got a great one. Cromwell v. County of Sac. This was back in 1876. We're talking about fraudulent bonds, missing courthouse funds. It's juicy stuff.
Yeah, so in Cromwell, you've got this guy, Cromwell, who tries to sue twice over similar bonds, claiming he was a bona fide purchaser, meaning he bought them in good faith, not knowing they were shady. But the court basically said, nope, you had your chance in the first lawsuit. We already established those bonds were issued fraudulently. Even though he was bringing up different bonds, that core issue, were they fraudulent? That was decided.
Right. So it shows how issue preclusion can protect someone from being dragged back to court over and over again for essentially the same underlying issue.
Yeah.
And it also shows how this idea of a bona fide purchaser, that can come into play even when you have something like fraud that's already been, decided upon.
Absolutely. And that's an important point. Issue preclusion doesn't mean that every single little thing from a case is off limits forever. It's about pinpointing those very specific points that have already been decided fairly, and there's a final judgment on them.
Okay, so we've got claim preclusion, which is about those entire claims, and issue preclusion, which is about those specific issues that have already been settled. But what happens when you have someone who wasn't even involved in the original lawsuit? Can they swoop in and use a past decision to their advantage? That's where it gets interesting, right?
Yeah, you're getting into like the strategy of it all now, and that's where mutuality comes in. You see, traditionally, both parties in the new lawsuit had to be the same as the old one for issue preclusion to apply, but courts have realized it's not always fair, so they've allowed for some flexibility with things like what's called defensive non-mutual issue preclusion.
So it's almost like getting a legal assist from a case you weren't even a part of. How does that work?
Okay, so picture this. You're being sued for something that a court already ruled on in a different case, but you weren't involved in that first one. With defensive non-mutual issue preclusion, you might be able to say, hold on, this issue's already been decided. I shouldn't be held liable based on that previous judgment.
Wow, so it's like using a past court decision as a shield to protect yourself. But I'm guessing there are limitations to when you can do that.
Oh, absolutely. Courts are really careful about applying a previous judgment to someone new. They want to make sure it's actually fair.
Yeah, it seems like there are a lot of factors to think about when deciding if it's actually fair to use an older judgment in a brand new case, especially when you've got someone new who's involved.
Yeah, and one of the biggest ones is whether that person, the one being hit with this issue preclusion, did they actually have a fair chance to be a part of that first lawsuit? Like, if they weren't a party to that original case, if they couldn't have joined in, then courts are much less likely to say, well, too bad, that old decision applies to you
Right.
anyway.
Everyone deserves their chance to make their case, right? But what if they could have joined that first lawsuit? Are there still reasons why a court might say, you know what, issue preclusion, it doesn't really apply here?
Absolutely, yeah. Courts will also look at whether the procedures were different between the two lawsuits. Like, were the rules of evidence the same? Was the burden of proof different? Because those variations, those differences, could make it unfair to just apply a judgment from one case to another.
Yeah, it's like you're comparing apples to oranges.
Right.
Sometimes the cases have got to be similar enough for this whole issue preclusion thing to make sense.
Exactly. And speaking of different types of cases, that whole burden of proof idea, that's a biggie in how issue preclusion works, especially when you're talking about criminal cases versus civil cases.
Okay, so burden of proof, that's all about who has to prove what,
Yeah.
right? And to what extent.
Precisely. So in a criminal case, the prosecution, they have to prove that the defendant is guilty beyond a reasonable doubt. That's a really high bar to clear. But in a civil case, the plaintiff, they usually just have to prove their case by a preponderance of the evidence, meaning it's more likely than not that their version of what happened is true.
Okay, so how does that difference, that burden of proof difference, how does that play into issue preclusion?
All right, so let's say you have a defendant, right? And they're found not guilty in a criminal trial. That means the prosecution couldn't prove their case beyond a reasonable doubt. Now, even if someone tries to sue that same defendant in a civil case based on the same basic facts, the defendant can't just be like, nope, I won the first case, issue preclusion.
Wait, really? Why not? They won.
They did win, but the standard of proof was different in that criminal trial. Just because the prosecution couldn't clear that really high bar of beyond a reasonable doubt doesn't mean that a plaintiff in a civil case using that lower standard preponderance of the evidence couldn't win.
So even if the underlying facts of the cases are pretty much the same, the fact that the level of proof needed is different, that changes things.
Exactly. It all comes down to what had to be proven in that initial case.
That's wild.
Yeah.
It really seems like there's a lot of nuance to when you can actually use this issue preclusion idea. Are there any other things that courts consider when they're making these decisions?
Definitely. A huge one is whether using issue preclusion would actually make the system more efficient or if it might lead to some kind of injustice. Courts are always trying to find that sweet spot between avoiding unnecessary litigation, not having people drag out the same arguments forever, but also making sure that the outcome is fair.
So it's not just about avoiding repeat lawsuits. It's about making sure the outcome is just, that it's right.
Exactly. And this whole fairness angle, it's especially important when you're talking about what we call offensive non-mutual issue preclusion. Remember, that's where a plaintiff in a new case is trying to use a past judgment against a defendant who wasn't even a part of that first case.
Right, I remember. It seemed like that scenario could be kind of, I don't know, a little iffy in terms of fairness.
Yeah, it definitely can be. Think about it. You're being held to a judgment from a lawsuit that you had nothing to do with, no chance to even argue your side. That's why courts are extra careful about allowing offensive, non-mutual issue preclusion.
So they're more open to the defensive use, where someone's protecting themselves with a previous ruling, but offensive use, where they're trying to use it as a weapon against someone new, that's where they're more hesitant.
That's a great way to put it. And here's another layer to this whole thing. Courts are especially careful about using offensive, non-mutual issue preclusion against the government.
Oh, interesting. Why is that? Does the government get some kind of special treatment or something?
It's not about special treatment, really. It's more about the bigger picture. You see, if the government was constantly worried about setting precedents that could then be used against them in future lawsuits by all sorts of different people, it might make them hesitant to really go after certain cases.
That makes sense. They wouldn't want to have to hold back just because of how a ruling might affect them down the line.
Exactly. The concern is that it could have what's called a chilling effect on the government's ability to actually enforce the law, So courts are generally reluctant to use offensive non-mutual issue preclusion against the government unless there's a really, really compelling reason to do so.
It sounds like this offensive use of issue preclusion really has courts walking a tightrope between efficiency and fairness.
For sure. And they've got to weigh all those factors we talked about. Did the party have a chance to participate in the original case? Were there procedural differences? What about the burden of proof? Is there a risk of an unfair outcome? Are there bigger policy concerns? All of that goes into making sure that issue preclusion is used fairly and appropriately.
So we've talked about how courts try to balance fairness and efficiency when they're deciding whether to apply issue preclusion. But are there ever situations where it's just crystal clear, like, nope, this issue shouldn't be relitigated, period?
Absolutely. And that's where this idea of essential to the judgment comes into play. This clarifies when an issue has really truly been decided and therefore is subject to issue preclusion.
Okay, so break that down for me. We know the issue has to be raised and actually argued in the first lawsuit, but what does it mean for it to be essential to the judgment?
Basically, it means that the court in that first lawsuit, they had to directly rule on that specific issue, and that ruling had to be crucial to the outcome of the entire case. If the court just made a ruling on something that didn't really affect their final decision, well, that might not be subject to issue preclusion later on.
So, like, if a court kind of made a side comment about an issue, but it wasn't a make or break point in their final decision, that wouldn't necessarily count.
Probably not, and there's a really famous case that illustrates this perfectly. Cambria v. Jeffrey, decided back in 1940. It was about a car accident, and in the first lawsuit, you had Jeffrey suing Cambria, and Jeffrey won. The court found that Cambria was negligent, and that negligence contributed to the accident.
Okay, so far, so good. Seems pretty straightforward.
But here's where it gets interesting. In the second lawsuit, Cambria turned around and sued Jeffrey. So you might be thinking, wait, didn't the first court already decide that Cambria was negligent?
Right. You'd think that would be the end of it.
And that's where essential to the judgment comes in. The court in Cambria v. Jeffrey, they said, hold on a second. Even though we found that Cambria was negligent in that first case, that finding, it wasn't essential to our final judgment. Because you see, they also found that Jeffrey was negligent in that first lawsuit, and his negligence alone was enough to decide the case. Cambria's negligence wasn't the deciding factor.
So even though they mentioned Cambria's negligence, it wasn't a deal breaker in the first lawsuit because Jeffrey's negligence was enough to, like, settle the score.
Exactly. And because Cambria's negligence wasn't essential to that first judgment, it couldn't be used as a basis for issue preclusion in the second lawsuit.
Oh, wow. Okay, so it's like the court is saying, we only decided what we absolutely had to decide and nothing more.
Precisely. And this whole requirement for an issue to be essential to the judgment, it shows how important that back and forth process is in our legal system. Both sides, they need to fully argue their case the first time around for issue preclusion to actually be fair in a later case.
Because if something wasn't fully argued, you can't really hold it against someone later.
Exactly. And there's another car accident case, Neenan v. Woodside from 1933, that shows this even more clearly. In the first lawsuit, you had a passenger, a guy named Hupman, and he sued the bus company, Woodside, and he won.
Okay, a familiar setup, another car accident, another attempt to use a prior judgment. But what makes this one different?
So in this case, the second lawsuit was filed by a different passenger, Neenan, and she sued both Woodside, the bus company, A&D Hupman, the passenger who won that first lawsuit.
Whoa, so she's saying that they were both at fault, the bus company, A&D, the other passenger. That's interesting.
Right. And here's where it gets even more interesting. Hupman, the passenger who won the first case, he tried to use that victory to defend himself in the second lawsuit. He was basically saying, hey, the court already said I wasn't at fault.
Yeah, I mean, that seems pretty reasonable on the surface. So what happened?
Well, here's the catch. Neenan, the passenger who was suing in the second lawsuit, she wasn't a part of that first case at all.
So she never even had a chance to present her side of the story about whether Hupman was negligent back then.
Exactly. And because of that, the court in Neenan v. Woodside said, nope, it wouldn't be fair to apply issue preclusion here. Neenan, she deserved her day in court to try to prove her case against Hupman regardless of what happened in that first lawsuit.
Again, it comes back to fairness. It seems like these preclusion concepts, they really add another layer of strategy to this whole legal chess game.
Oh, for sure. Understanding when you can use a previous judgment and when you can't, it can completely change the game. And that's why it's so important to look at each case really carefully. What were the specific issues? Who are the parties involved? And ultimately, is it actually fair and just to apply issue preclusion in this new situation?
So before we wrap up this deep dive into these fascinating but kind of complicated legal doctrines, I want to circle back to something we touched on earlier. Defensive and offensive non-mutual issue preclusion. I just want to make sure I've got it straight in my head.
Absolutely. So just to refresh our memories a bit,
Yeah.
both defensive and offensive non-mutual issue preclusion, they both involve using an old judgment in a new case, right? And in these cases, at least one of the parties wasn't actually involved in that first lawsuit.
Right. So you've got someone new who's either benefiting from or maybe being, I don't know, kind of stuck with a decision that they weren't even around for.
Yeah, exactly. Now, with defensive non-mutual issue preclusion, it's the defendant in the new case who's using that old judgment,
Right.
and they're using it to protect themselves, basically saying, look, this issue, it was already decided in a prior case, and I can't be held responsible for it now.
Yeah, like we went to court over this. It's settled. Case closed.
Exactly. And courts are usually more open to this kind of issue preclusion, as we've been saying. It helps the system run smoothly, and it makes sure the rulings are consistent. If a fair decision has already been made, why waste time and resources redoing the whole thing, right?
Right. No point in reinventing the wheel.
Yeah.
Okay. But then you flip that around and you've got offensive non-mutual issue preclusion, and that's where things get a little trickier, right? That's where the plaintiff in the new case is trying to use an older judgment to their advantage, even though the defendant wasn't a part of that original lawsuit.
Exactly. And you can imagine why courts are much more hesitant about this one, right? I mean, think about it. Someone's trying to use a judgment from a lawsuit you weren't even involved in against you. It just feels inherently unfair.
Definitely raises some eyebrows, for sure.
For sure. And that's why courts have all those safeguards we talked about, those factors they have to consider. Could the person being hit with this issue preclusion have joined the first lawsuit? Were there differences in how the two cases were handled? Is there a chance of getting conflicting judgments? They really scrutinize those situations.
It's like they're constantly trying to find that balance, right, between preventing unnecessary lawsuits, but also making sure everyone gets a fair hearing.
Exactly. Striking that balance, that's what it's all about.
Yep.
And it's fascinating, honestly, to see how all these concepts play out in real-life cases. The law is constantly changing and evolving, and each new case brings a new perspective to these already complex topics.
It's been a wild ride, that's for sure. We've covered so much ground today, the difference between claim preclusion and issue preclusion, what mutuality even means, those landmark cases that shaped how we think about all this, the whole idea of essential to the judgment, how the burden of proof can change things, and that never-ending struggle to balance efficiency and fairness in the legal system.
It's been a pleasure diving into these legal weeds with you. And remember, this might all seem very technical and legalistic, but these doctrines, they really matter. They shape how our legal system actually works, how it functions on a day-to-day basis, and that impacts everything and everyone, from individual cases to those huge legal precedents that can affect us all.
Absolutely. It just goes to show a little legal knowledge can go a long way. So next time you hear about some big court case, or maybe even find yourself facing a legal issue, think back to our chat today. You might surprise yourself with how much you remember and how well you understand what's going on. Thanks for joining us on this deep dive.